pleasure to welcome you all to this special lecture on the goals and functions of international economic law organized by Indian Society of International Law. We are deeply honored to have with us today one of the foremost scholars in international law, Professor Michael Waibel, Professor of International Law at the University of Vienna. This topic holds particular relevance in the context of today's globalized economy, where the intersections of trade, investment, and economic governance pose complex legal challenges. We are fortunate to have Professor Waibel with us to provide his insights on this critical issue. To begin with, I would like to request our President, Shri Praveen H. Parekh sir, to felicitate our guest, and I also request our Secretary General sir to present the publications of Society to the guest.
Yes. Welcome. Thank you.
Now I would like to request our Secretary General sir, Shri Narendra Singh sir, to deliver the welcome address.
Good afternoon. It is my pleasure to welcome to the Indian Society of International Law Professor Michael Waibel, Professor of International Law at the University of Vienna. He has had a very distinguished career. He has served in a number of international organizations like the World Bank, the International Monetary Fund. He is a member of various international societies, editor-in-chief of the Journal of International Economic Law, and general editor of the ICSID reports. Now, Professor Michael Waibel has a number of areas on which he researches and he writes, including on international dispute settlement, including arbitration, international financial law, sovereign debt and financial crisis, international investment law, the law of treaties, the law of economics, law and economics, and on the European Monetary Union. He has taught at the University of Cambridge, at the Lauterbach Center for International Law, and he has been a visiting professor in law and economics at the University of St. Gallen, and was the Nomura visiting professor of international finance systems at Harvard Law School. He studied law at the University of Vienna, Paris, and at the London School of Economics. So we are very fortunate to have him here today, and he would be speaking on the goals and functions of international economy. Now, as you're aware, during the last few decades, following the period of globalization, while globalization led to great prosperity, increase in trade, there were also concerns that all countries did not benefit to the same extent, and many countries were being left behind. And I think we look to Professor Waibel to see what are his insights and what solutions he provides to having greater equality in the international economic law. Thank you.
Thank you very much for this very kind introduction. Thank you to everyone for being here. Thank you, President. Thank you, Secretary General. for hosting me and for the Indian Society of International Law for organizing this afternoon's lecture. What I want to survey this afternoon is what are the goals and functions of international economic law, and how have these goals and functions of international economic law evolved over time. So this is going to be quite a high-level survey, and I very much look forward to your questions, criticisms, and comments on what I'm going to say. In a nutshell, I'm first going to look at what are goals and functions of international economic law as a whole. So if we think about trade law, investment law, monetary and financial law, and tax law, what do these areas, among other areas of international law, have in common in terms of their functions and goals? And then in a second step, I'm going to look inside particular areas of international economic law, namely trade, investment, monetary, financial, and tax, to look at what are the functions of these particular areas or regimes, and we'll see that there are some important differences in what these these areas try to achieve. And there's probably greater scope, especially when it comes to thinking about how can we improve international economic law going forward, making sure that it is more inclusive, that it benefits all countries, that these areas of international economic law can learn from one another. Just to foreshadow, I'm going to suggest that there are 5 basic functions of international economic law. First, producing global public goods, peace, but also international economic stability. The second function is managing interdependence between states to ensure that actions taken by one or more states do not have significantly adverse effects on other states. Third, enhancing global economic welfare through increasing economic exchange. And then, the next 2 functions, function 4 and 5, are more focused on individual economic operators. Fourth function is the creation of stable rules to enable economic operators to plan ahead. And fifth, to protect businesses and individuals, economic operators, from arbitrary state action. Now this is an approximation of what I think the functions of international economic law are, and these functions also overlap. The first 3 have a macro quality. They are about public goods, aggregate economic welfare, and so on. Whereas the 4th and 5th function focus on the micro level. But they focus on the micro level, providing predictability for economic operators, for example, in the interest of helping with the first 3 functions. But there can be significant tensions between these goals, and in particular between the micro goals of international economic law and these macro goals. And arguably that's exactly what we have seen in several important areas of international economic law. Think about the direction in which international investment law, for example, has developed in the last 25 years or so, when investor-state arbitration has come to the fore. Or think about the direction of travel of international tax law. Until quite recently, there was a strong focus on enabling, or at least that was tolerated by international tax law, on enabling tax structuring without regard, or with little regard, with limited regard, for the tax base of countries. The focus was on avoiding double taxation. That was the overriding goal. Now, in more recent years, we have seen a shift, or at least a partial shift, towards avoiding double non-taxation. We want to ensure that businesses, and individuals too, but I'll focus on businesses, pay tax at least somewhere, at least in one country, in respect of their economic activities. Now that shift is arguably incomplete, and it's a shift that has been driven by a small group of countries, namely OECD countries, and that might indicate that international economic law, in this case in international tax law, continues to privilege the interests of a smaller group of countries over the interests of all countries. So no doubt, in this area and other areas of international economic law, just like in public international law more generally, there is a lot of contestation and certainly room for a debate. That's why it's also, and I'll say something about this in conclusion, why it's important to highlight that there are important distributional effects and that power is never far from the surface. So international economic law, according to critics, has played a key role in enabling dominance by powerful states and powerful economic actors, which in some cases, of course, are, certainly in economic terms, far more powerful than most states. And that has led to a reassessment in both developed and developing countries of international economic law, thinking more about security, resilience, sustainability, given the environmental challenges, and social inclusion. Now let me briefly say a bit more about these 5 functions of international economic law that I have outlined. Delivering public goods, order and economic stability, and ultimately peace. This is, if international economic law can help provide for order, peace, and stability, this is a public good. It benefits everyone, large and small countries, developing and developed. And it's a very important lesson that the drafters of the post-World War II order drew from the interwar period, the period between the two world wars, where European powers in particular, not only but especially European powers, think of Germany above all, but also Britain, were major contributors to economic and then of course also political instability. So this first function is at the very macro level. International economic law, that's the aspiration, can provide guardrails against political extremism by delivering stability. By ensuring, for example, and we can see this clearly in international monetary law, think of the International Monetary Fund, that we have at the very macro level financial and monetary stability. If you look at Article 1 of the IMF Articles of Agreements, which sets out the functions, the goals of the IMF, we see prominently there the need to promote exchange stability. So stability in exchange rates among members and a reference to orderly exchange arrangements. This, the drafters of the IMF considered to be the foundation for international economic exchange. Similarly, international economic law can help to make international economic relations a source of conflict. Gunboat diplomacy, very common in the 19th century and early 20th century, was seen as something that the world should leave behind, and dispute settlement, peaceful dispute settlement, without inviting the abuses of diplomatic protection by powerful states, was an important motivation, an important early motivation for developing systems of dispute resolution in the trade area, and later in investment too. And that can be seen as a very real achievement. At the same time, critics allege that international economic law hasn't been able to depoliticize dispute settlement. Think of investor-state arbitration or major trade dispute. There might be some reduction in how much politics there is in these disputes as a result of third-party adjudication. But at the end of the day, there is an important degree of politics still in these disputes. And that's perhaps not necessarily a bad. Moving on to the second function of international economic law as a whole, managing interdependence and reducing externalities. The key idea here is that international economic law enables countries to cooperate if they wish and to reduce negative effects that one country's action have on other countries. In other words, so that countries can better manage their independence. We can see this in trade, for example. We have large markets, large countries that can affect the terms of trade in their favor. International trade law seeks to constrain that constant temptation for a large country to use their market power. Reciprocity is at the very heart of how international trade law tries to achieve this. We can also see reciprocity and this desire to manage independence and reduce externalities in international monetary law. In the period between the two world wars, we saw tit-for-tat responses. Countries devalued their exchange rates, and that arguably was a major contributing factor to the Great Depression. The drafters of the IMF said we need to break decisively with these desperate tactics of the past. We need a managed system, and they created the Bretton Woods system of fixed exchange rates, recognizing that the exchange rate is a crucial policy dimension. But at the same time, for the first couple of decades of the IMF's existence, protecting state regulatory autonomy. So enabling states to pursue their macroeconomic policies under a system of fixed exchange. We can see similar developments in international financial law, but just like in international tax law, there are prominent allegations that international financial law often reflects developed country priorities because of the actors who have played the major role in developing this area of international economic law, that is mostly developed countries. Turning to the third function of international economic law, growth and sustainable development. So here the focus is on increasing the aggregate pie, making the world better off. Notably, of course, the focus is not on the distribution of gains, which has become a major question. It's always been a major question, but it has become an even bigger question in recent times. So countries commit not to impose tariffs above a certain level because that is going to benefit everyone. They protect investment because once an investor, a foreign investor, has committed capital, there is a temptation to take that capital or adversely affect that capital, and that might lead to investment not happening in the first place. So countries have tried and arguably competed with another, perhaps competed too much in recent decades to outdo each other in protecting foreign investors, to create the most favorable conditions imaginable for foreign investors, and thereby overlooking what this might mean for their own regulatory autonomy. So that's the third function. Moving to the two micro functions briefly. Fourth function, stabilizing rules to enable planning by economic actors. So this is a function that rose in prominence after the end of the Cold War in the early 1990s, perhaps in keeping with the seeming triumph of the US market-oriented economic model. A focus on providing clear rules up front so that economic actors could plan ahead. They knew how much they were going to be taxed. They knew was the idea that their investments would be protected. They knew what the tariffs were going to be that applied, so that they could choose where to build cars and so forth. So focus on providing predictability for economic actors so as to increase economic exchange and grow the aggregate of economic economy. We see this in trade, in investment. There was, for several decades, a strong emphasis on the predictability of the legal environment for investors, and we see it in the tax area as well. Now, this predictability for private economic operators has a darker side, and that darker side is that it can raise very serious questions about national economic priorities and democratic choices. It may mean that countries struggle to change direction, to implement new economic policies, for example, to protect the environment, to benefit social inclusion, and so on. Now, in principle, states can enact these policies, but it might become a very expensive proposition. Hence, growing concern about what has come to be known as regulatory JIEL. Not only if we have dispute settlement that is initiated by other states or by private actors in investor-state arbitration, do governments refrain from regulating in the public interest. Also, the mere possibility of such adjudication constrains governments in practice from enacting regulation in the public interest that gives effect to democratic choice. The fifth and final function of international economic law as a whole is to protect private economic operators from arbitrary state action. This overlaps with the fourth function of predictability, but it goes further because here there is an emphasis on ensuring that traders, investors, taxpayers, and so on are treated fairly. Now, of course, what exactly is fair is very much in the eye of the beholder. So if we think, for example, about investment treaties and the system of investor-state arbitration that they have created, there has been growing backlash and growing concern about reverse discrimination, that these treaties treat foreign investors more favorably than domestic investors. And that creates level playing field concerns and isn't actually a good policy choice in terms of ensuring efficiency, because through international treaties we provide more favorable treatment to one set of investors, and often investors that meet a particular nationality requirement over other investors. We can also see this in the area of exchange rates. Following the collapse of the Bretton Woods system in the 1970s, and when the world moved, at least initially, developed countries moved to a system of floating exchange rates, there have been repeated allegations that countries seek to influence the exchange rate to improve their competitive position. And this is known as artificially undervaluing exchange rates. Has led, for example, it's just one example, to major tension in the trade relationship between the two largest economies, China and the United States, for the last 15 years or so, and is still not resolved. So those are 5 functions, I suggest, of international economic law as a whole. Now let me briefly outline functions within particular regimes of international economic law. Starting with international trade law. International trade law, with the creation of the GATT in 1948, focused initially on progressive liberalization, enhancing market access, arguably not paying much regard, or perhaps not sufficient regard, but to non-trade concerns. Investment law is very different. It hasn't focused on market access or on liberalization. In fact, that hasn't been the function of most investment treaties. Most countries refuse admission to investors, including to particular investors, including for entirely arbitrary reasons. So in general, there is no issue here. So today, with investment screening mechanisms, the countries have increasingly adopted to ensure that their security and other interests are protected. And there is no significant tension there because investment treaties, for the most part, have focused on protecting investors. That is, once a host country has made a discretionary decision whether or not to admit an investment, that investment once made is protected. Now, in the last 15 years or so, there has been a backlash because countries increasingly have come to realize that investor-state arbitration has real bite, and that a high degree of investor protection, as enshrined in many investment treaties, does not sufficiently protect host-state regulatory autonomy. So we've seen a partial move away from focusing solely on investor protection, greater account taken now of regulatory autonomy. In the monetary sphere, we have a focus throughout the Bretton Woods period and more recently on financial stability, both for its own sake, because having instability in financial and monetary matters is really undesirable. It's really undesirable because it's not good for international economic exchange, but more fundamentally because it endangers international order and ultimately peace. Once the Bretton Woods system collapsed, there has been a greater emphasis on financial assistance. Countries have greater need for emergency financial assistance from the International Monetary Fund, among other institutions. And lastly, international tax. As I've already briefly said before, here we have seen a very important shift. Traditionally, international tax treaties have pursued one goal, and one goal only, that is to avoid double taxation. The perceived unfairness that a taxpayer would need to pay tax to 2 or more countries for the same income. But because of arguably pervasive tax planning, particularly by sophisticated, larger economic operators, countries have adjusted, or are still in the process of adjusting the international tax regime to protect their tax base. India, for example, has renegotiated an important tax treaty with Mauritius that wasn't seen as being sufficiently protective of India's interests in taxing investors who use Mauritius as a jurisdiction to invest in other African countries, for example. So here too we have fairness concerns that have become more prominent, ensuring that taxpayers pay tax at least in one country. Hence also the proposal, still a proposal for the time being, of a global minimum tax, still a proposal that has been pushed by OECD member countries above. And this has gone hand in hand, and I'll conclude on this, with a much greater emphasis, much more attention being given to the role of power in and distribution. Now, this has always been a focus of more critical approaches to international economic law, such as third world approaches to international economic law, that has long highlighted that we have abuses by powerful states, including of hegemonic powers, taking raw materials with giving very little in return, perhaps vague promises of transfer technology, even for shared goals such as protecting the world's ecosystems and combating climate change. These approaches highlight that there are important biases in international economic law, actors and the key actors in international economic law that provide advantages to powerful states and their constituents. And we can see this is one of the major criticisms of more critical approaches in the Agreement on Trade-related aspects of intellectual property rights. Still, many of the IP rights holders are based in developed countries. So enshrining a high level of protection for IP rights, copyright, patents, and so on ensures that there are significant license fees that are paid largely by users, license holders, to IP rights holders in developed countries. Now this can be seen as perpetuating economic domination by a relatively small group of countries. So while in principle the TRIPS agreement is facially neutral, it operates in a, arguably, according to this criticism, in a highly asymmetric way. And similar criticisms have been made, among others, of investment treaties too, to the extent that investment flows aren't in practice two-way, but we have one country, country A, that exports capital, that investors from that country, and virtually no investment in the other direction. Investment treaties in practice are also highly asymmetrical instruments. And one needs to think at least carefully about whether a country that has hardly any investment that it makes in the respective counterparty, whether it should enter into such a treaty to begin with. So let me end there, and I very much look forward to any questions that you may have. Thank you.
Thank you so much, sir, for your expert insights on this pressing issue.
Some questions.
We can take some questions.
I have a question. Please. My name is Vinita. See, my question is, actually I used the word license fee, wherein a company authorizes some other organization on their behalf, this is what my understanding is, to manufacture their products or provide their services. Correct me if I'm wrong. So, is this the word license fee and the franchisee fee are interchangeable, or is there some difference between them? You said license fee, just when you were talking about the IPR in your last few words.
Yes, so I was referring to fees associated with IP rights. So not franchise fees related to franchises and so on. So to the extent, so we arguably have a pretty unequal distribution of IP rights. So the technological endowments, if you think about patents, are still pretty unequal. Now things are changing, but many patents are concentrated in a small number of countries. Now China has been catching up, really caught up with some of the most, with the traditional patent powerhouses, but many countries have very few patents or other IP rights holders. So that leads, that was the point, to unequal payments associated with these IP rights. And that's arguably a concern if we have a one-size-fits-all protection, minimum protection regime that is part of the WTO. Right?
Yes, please.
I am Adivit Sai, a lawyer practicing in domestic law as well as international, having office in Europe as well, studying in Europe as well. So I fully agree with you, whatever you have said, congratulations that you have given an excellent insight into the international economic law. But at the same time, having said all the good qualities or advantages of international economic law, we also face a lot of problems, especially from the Indian perspective as well as third world countries as well as economic developing countries. So far, the world economy is completely managed by the new world order after the Second World War. As you have rightly said, they have drafted the international economic /business/trade law, and everything is made in their favor. They have completely ignored the interest of third world countries, economic countries, including the environmental law. As you know very well, India has always tried to raise these points in the international forum, and also human rights in all respects. What do you say about it? And secondly, with respect to PCT applications, you are coming from Vienna. I have a very serious and strong objection. Though we file PCT application in one of the countries, still we are compelled to file PCT application in each country, and it is all making a lot of troubles for the international traders, especially for the traders or business people from India, because you know they are not that rich from India. We still try to thrive our business in the international business area. That is number two. Number three, with respect to taxation, international taxation, still an Indian goes to some other European country, including Vienna, and he tries to live there or he tries to settle his business, and when he comes back and he lives here, he is compelled to pay tax over there, though he is living here for more than 181 days as per the double taxation agreement signed between bilateral countries. So, you know, still there are a lot of things to be cleared. And I raise this issue because I have seen that you are a co-editor in law, you are a chief co-editor and professor of international law. I am sure that you are also one of the drafters of some international laws.
Thank you. So I probably can't do justice to all your questions. Perhaps let me start in reverse order. Before I come to your third question, I mean, my intention has not been to underplay the major problems that international economic law, just arguably international law more generally, has. But I think there are some achievements that they are fragile. These achievements have also led to benefits being pretty unequally distributed across countries. So I think there is certainly a lot of scope for improvement, and I think it is increasingly difficult. It has been difficult to justify, of course, for some time, that we have a system that continues to privilege the distribution of economic and political power as it was in the period after World War II, how how much the world has changed. We see this in many international institutions. The IMF is a very good example. If you look at the distribution of IMF voting power, it's extremely difficult to justify the current quotas that we have in the IMF. Now, on your question about taxation, when I said we have more recently an emphasis on ensuring fair taxation of taxpayers, this is not to belittle the importance of still dealing with what is in many cases continues to be a major problem of double taxation, of genuine cases of double taxation. Like in your example, so not taxing people more than once for the same income, that continues to be a very important function of international tax law. But at the same time, there has been growing emphasis on information exchange to ensure that taxpayers cannot game the system. They can't play it, they can't use it to obtain an unfair advantage, which in this area is you're not taxed at all, or at least you're taxed to a very minimal degree. We've just had a judgment of the European Court of Justice. Google has an effective tax rate in Ireland of 1%. Is this really the kind of international tax system that we collectively want? And while, and I think this leads me to your second question, while there are, of course, very significant inequities in between, if we compare developing countries and developed countries, I think it's not just about these groupings, and of course these are also imperfect. So China has very different characteristics from Indonesia or South Africa, even though they're all developing countries, or India for that matter. Restraining unilateralism and restraining the countries pursue their own advantages at all costs, that is something that international law, and including international economic law, to which it can contribute, but we see this also in the relationship between developed countries. So if we think about the foundation of the creation of the International Monetary Fund in 1944, the United Kingdom and the United States, developed countries, were the most important countries in terms of influencing the design of the IMF. But at the end of the day, the United States called the shots because it had won the war. Yes, the UK had also won the war, but it had suffered terribly in economic terms and human terms. And the United States took advantage, one could say, of that situation as it presented itself in 1944, 1945, to enshrine the US dollar as the world's preeminent currency, and that has provided very enduring advantages to the United States vis-a-vis all countries, including the developed.
Any other question?
So there's a question online. So what is the future of international economic law as it transformed till today visibly?
What was the last part?
As it has transformed till today visibly.
Well, that's the million-dollar question. I think a number of developments in the last 2 decades give one a lot of food for thought about whether there is a future for international economic law, or certainly whether that future is particularly bright. Now, at the same time, even though we have had these major centrifugal tendencies, right? So, for example, the United States, through both Democratic and Republican administrations, no longer supporting the dispute settlement system of the WTO. This is under Democratic and Republican presidents. Somehow international trade law has survived. So it has also shown, and you can see this in other areas too, surprising resilience. When the United States pushed the IMF in 2007 to investigate China for artificially undervaluing its exchange rate, and this led to a major backlash in China, it created major difficulties for the IMF in the short run. But the IMF is still here. It has many problems, including the quota distribution, including that it perhaps doesn't fully, that it is too much of an institution where there might be too much groupthink in policy terms and other problems, but it's an institution that remains, it's an institution that still has managed more or less, and we can debate whether it's more or less, to deliver on its core mandate, which is international monetary stability.
So this question was asked by Dr. Ashok Kumar Sharma.
Okay, thank you. So,
Yes,
So
I
my
have a question.
yeah, yeah, please. Well, after that, next you.
Yes, sure.
Please.
Hi, good evening, Professor. My name is Manda. I'm an assistant professor at Center for Trade and Investment Law. So I was just going to ask something along the similar lines as to future of international economic law. So one of the goals of IEL, at least in the context of WTO, is global trade governance. And as you rightly said, with the impasse of resurgence of the appellate body, one of the things that really asks what is going to be the future of WTO, given that we see a resurgence of, let's say, industrial policy, and now we are moving towards plurilateralism. So what do you think now is the goal of WTO in context of global trade governance? How is it going to get all the players back at the table? Is this a shift in at least the trade aspect of international economic law?
Yes, I think we have seen an important shift towards, as you mentioned, towards plurilateralism. So things, a lot of things happen outside the WTO. Now, one can take a pretty negative view of that, and some people do. I think maybe at the end of the day, where this governance happens is less important than that we have functioning institutions. So just because one institution, even an institution as central as the WTO, becomes somewhat less important, right? It hasn't really achieved significant liberalization in the last 15 years. New liberalization initiatives have not borne fruition. That by itself, I think, doesn't mean that the institution itself or the larger regime of international economic law, which it forms part, is dysfunctional or has become irrelevant. So I think we are, with little doubt, moving in the direction of a more pluralist world in trade and other areas. But it's very important that this be managed well, and I think there is the danger that in a plurilateral context, that power and economic differentials play an even more important role than they already do in multilateral institutions.
Yeah, you can
Yeah,
ask.
Professor Michael, you explained the 5 functions and very nicely explained, but my question is this, that the last function of economic law is to protect businesses and individuals from the arbitrary actions of the state. So can we say that the birth of the bilateral investment treaties were an outcome of this last function? Can we say like that, that the BITs were born to fulfill the last goal of the Indian economic law, international economic law?
Yes, thank you. Yes, I think that was an important rationale for investment treaties initially. If you include in that, as I would, ensuring that states, if they decide, which they of course can decide to do, if they decide to expropriate investments, that they have to pay compensation for such expropriations. I don't think it's the only reason why we have investment treaties, and I think there are still very important questions, for example, about do investment treaties strike the right balance when it comes to large-scale reforms? So think about land reform. If there is a duty to pay fair market value compensation, that makes it, in some cases at least, prohibitively expensive to carry out such reforms. And before investment treaties came to the fore, some of these instances have been handled through lump sum compensation agreements or other instruments. And there is a significant difference between that approach and what we have represented in investment treaties. And I think in some quarters, at least, a realization that investment treaties put too much emphasis on protecting individual actors from arbitrary state action at the expense of the public interest.
So can we say that the BITs actually give empowerment to the last function of the economic law?
Yes, I think this function is very important traditionally for BITs. It may become less important going forward.
Any other question?
Yes, sir.
So may I
Now,
ask
Professor
one question?
Waibel,
After this, secretary general. Next.
if we look back at the 1960s and 70s, that was the period when there were demands for a new international economic order. And some components of that demand included code of conduct on multinationals, code of conduct on transfer of technology, and some of the big issues at that time were the question of transfer pricing and other restrictive practices of multinationals. This transfer pricing is now moving in the other direction. Whereas it was earlier, the developing countries which were facing the issue. Today, as you mentioned, you have the US and the UK complaining that their biggest corporations are moving their headquarters to countries where they pay little or no tax. And many big corporations in the US are trying to move out due to tax reasons, to save taxes. Now, after this, there came the period of globalizing, the change in the political scenarios in countries moving from the socialist system to more open economies. And that is when we started having the investment treaties. And at that time, maybe the developing countries were more confident that they could manage the multinational operations in their own territories. Now, we have come to another stage where there is a dissatisfaction with the dispute settlement process in those set out in these investment treaties, and that there's demands for reform and others. Was it that the investment process was not properly understood by developing countries when they welcomed the multinationals and the big capital? Or was it that it was too early for them to have entered into these treaties without fully understanding the way big business works? And how do you see the future moving forward?
Thank you for this very wide-ranging question. I think, so specifically with respect to investment treaties, I'm not sure that any country, so I would include the United States, France, Japan, fully understood what this would mean. And I think at the beginning of your question, you highlighted that it's often only once what some call, and I use this in quotation marks, the core of the world economy realizes that it concerns them that things change. And I think that's a real concern, that, and it suggests that there is too much focus on the interests of individual countries, often at the expense of developing countries. Now, as you underscored, and as you know better than I do, this is something that the new international economic order sought to challenge probably ultimately not very successfully. You mentioned technology transfer. This would be if we had robust systems for technology transfer, this could really make a significant difference, but this hasn't materialized. We have extremely weak technology transfer provisions in the TRIPS agreement, in environmental agreements, even though we have affirmation after affirmation how important a shared priority climate change is. But countries that have technology, have a lot of technology, continue to be very attached to their technology endowments, and that's a major stumbling block. Perhaps one final thought. So I don't think it's all interest, as your question also suggested. It's also sometimes ideas, and these ideas can change. So in the early 1990s, we saw ideas among policy makers changing. So even countries that had pretty closed systems until then suddenly welcomed foreign investment. And I don't think this was all driven by sinister multinationals and lobbying. I think at the time there was some genuine hope, or perhaps more than hope, that this would make a positive contribution to economic development. Now, it did lead, after the experience of 10 or 15 years, to a significant reevaluation. So ideas continue to evolve. So this is, I think, for many countries, really also a trial by doing. You see, you try something and you see whether it works. But the important thing is once you realize it does not work as intended, that you recalibrate. And that international economic law allows such recalibration. The countries are
Two more questions from two persons. Any two? Please.
I just want to ask that international economic law is concerned with the peaceful time, because whenever there is a war between the countries or among the countries, it gets at stake. The investment, the traders, the business operators, they all left at the mercy of the war. And they are, as we already clearly admitting that some states are very powerful, they make the rules, they play effectively. What about the weaker section? How the international economic law comes during the wartime to save those weaker sections or the states? This is the question.
Well, I think we can think of international economic law as what international lawyers traditionally call the law of peace. Right. So it's a system of rules and principles that applies during when there is no armed conflict. It hopes to contribute, as I suggested, to maintaining order and peace, but once that order disappears, peace is replaced by armed conflict, it arguably has no role whatsoever. Now, I think there are some examples of international economic law. You mentioned investment, where international economic law has started to play some role also during periods of armed conflict. And even more so than perhaps during peacetime, it exposes major tensions between rules of international economic law and the law of armed conflict and so forth, the law of war. So if you have large-scale destruction of property, including property of foreign investors during an armed conflict, is there any role? That's an important question with no clear answer. Is there any role for investment protection? Or is it just the law of armed conflict that applies? And we have different answers that different tribunals have given to that question.
Last question. Yes? Anyone? All right. Okay, now.
Thank you so much, Professor. I would now like to request our President, Dr. Waibel sir, to give his remarks.
Professor Waibel, and your friends are very, very happy
In fact, we learn every day. And of course, there are students, of course, they have to learn every day. But I can tell you that I learn every day. And the wonderful thing which I have learned today, I did not know. Any of it I did not know. It's very good. I think it's always good to keep on learning. And one organization of ours, of Indian Society of International, does it so very well. We have got professors, we have got the lawyers, and we have a large number of students. And students does not mean that you have to be only 20 years or 30 years or 40 years. A small young man like me of 81 also can be a student. And I am a student. It is my great honor and privilege to welcome to our great friend who has come from all over, and on behalf of each one of you, I would like you to give them a thank. Professor Waibel is a renowned scholar and distinguished professor of international law at the University of Vienna. His contributions to the field are vast and impactful, particularly in the areas of international economic law, sovereign debt, and international dispute settlements. All these issues are very, very important for everyone, including to India, and therefore, of course, all of us. He has been recognized globally for this outstanding research, having received the prestigious prize from the American Society of International Law, the book prize from the Europe Society of International Law, and Mr. Lieberhuhn prize, etc., etc. And we also, from India, give you all the best for future from today onwards. In addition to these academic achievements, Professor Waibel serves as the co-editor-in-chief of the Journal of International Economic Law and the general editor of the ICSID reports. His scholarly work includes a critically acclaimed book, Sovereign Defaults Before International Courts and Tribunals, which provides a comprehensive analysis of how international tribunals handle disputes related to sovereign debts. International economic law is a cornerstone of global economic governance. In fact, now it is global has become really for each one of us and each one of the countries. Nobody can be away from it, and nobody wants to be away. It encompasses the rules and principles that govern economic relations between states and other international actors. This field of law is crucial for regulating international trade, investment, finance, and developments. It aims to promote economic cooperation, ensure fair competition, and facilitate the peaceful resolution of economic disputes. The goals of international economic law are that they include fostering international economic stability, promoting sustainable development, and ensuring that economic activities respect human rights and environmental standards. Very, very important. Human rights and environmental standards. This legal framework also seeks to balance the interest of developed and developing countries, providing mechanism for equitable treatment, preferential support for the emerging economies. Professor, insights into your statement informing us today is very useful for all of us. Your extensive research and practical experience offers a unique perspective on how international economic law can adapt to the challenges of globalization and economic interdependence. There was a time when India was not very much accepted internationally, but today India is very, very important very, very important for the whole world, and we are very happy that you have come here and we have learned a lot of it, and we are all students, as I said. That I'm of course a student, and I want to remain a student. Every day we learn, and sometimes I learn from my students. They come and tell me something, and I say, well, I did not know. I must say I did not know. These youngsters are very good these days. They're so well, etc. It's very good. I'm very, very happy. And I'm also happy that more and more girls are also now coming in all over our organizations for us, which is very good because they have equal rights. Or Professor, you said they should have 51% and the men should have 49%. All right. Now, as we gather here today, we look forward to the learning from professors' expertise and engaging in a meaningful dialogue about the future international economic law. Lecture promises to our understanding of the legal mechanism and global economy and inspire us to contribute. Please let us thank you very much to Professor. Thank you very much.
Thank you so much everyone for coming, and thank you so much Professor for gracing the occasion. Tea is served.
Please, all of you, please have tea.